Okay. If the parties, court reporters and interpreters are ready to proceed, then we can do so. And it is now the turn of Doctors Langstroth and Calvo. Yes, I thought there might be something mistaken in the way the cards had been arranged. Of course. Okay. You will both be testifying in English, correct?
Yes.
That's correct.
Okay. As expert witnesses, you will, after the initial questions from counsel to claimants, you will be enabled to make a presentation to be followed, as you have identified, by a cross-examination on the part of counsel to the Republic of Costa Rica, and thereafter by some questions, if they feel the need to do so, by counsel to claimants. As you are aware, the tribunal may ask questions in between if it deems advisable to do so. Although this is a joint report that you have prepared and we have gone through the exercise of who would be responding, my understanding, and I would ask you to confirm, that questions can be presented to either one of you, and I would like us to establish how the rules will be followed as to if a question is presented, for example, to Dr. Langstroth, if he needs to respond, or Dr. Calvo will be enabled to do so. So before we proceed with the examination, I think those rules should be clear. But once we identify this, the process is, as you are aware, the answers shall need to be made. Clarifying questions may be made afterwards. And if you are unaware or do not understand well a certain question, please feel free to request any clarification. And finally, there's a statement that I would ask both of you to read to your participation as experts.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Okay. Thank you. Mr. Burton?
Thank you. Just for formality's sake, Doctors Calvo and Langstroth, you have in front of you a file. There ought to be at the top of that file a copy of your report. I'd be grateful if you could just quickly inspect the report and confirm whether or not that is your report.
Yes, it is.
Do you have any amendments or revisions
Excuse
to
me,
make?
if I could have clarification as to which witness is which witness.
On your right, looking at you from your right,
The
that's
one
Dr.
with the
Calvo.
accent is
It's
Calvo.
Dr. Calvo. On the left, Dr. Langstroth.
Thank you so much. I apologize for the interruption.
Okay. Are there any revisions or amendments you need to make?
None.
Actually, I don't think there's a signature on this, but you would confirm in any event that even in the absence of a signature that it is your joint report.
This is our report.
Thank you very much. No further questions.
Thank you, sir. May I just make a short suggestion on the protocol perhaps we adopt? I will have questions for specifically Drs. Calvo and Langstroth respectively during the course of my cross-examination. If there's a general question, it should be incumbent on me to try and direct it. If I don't, may I make a suggestion that the first person or that the person that the gentleman believes should be best placed to respond answer, but that they answer the then subsequent questions until there's a break in the theme, or unless if I were to just pose the same question or a modification of it to the other doctor for a specific reason.
So what you are referring to is if there's a question and there's follow-up questions on the answers, that it be the same person who started addressing the answer who should proceed with that line of questioning.
I would suggest that as a starting point, sir. I'm highly appreciative that the tribunal want to understand this, and so it's in your interest that you have an answer and that there be no games playing in that regard. So just to express that goodwill on our part as well, sir.
Thank you.
Sorry, can I just intervene on that? I don't fundamentally disagree with Mr. Leathley's observations, except to say that all experts owe a duty to the tribunal and to the process, and it is therefore possible, I put it no higher than that one or other may have a slightly different view in relation to a particular question. So there must always be afforded the opportunity for an intervention if Dr. Langstroth takes a different view to Dr. Calvo on a particular point. Not that I think there are any differences, but just to say that must be afforded to any expert in order that they can just discharge their duties to you.
Indeed, but that should be after that line of questioning has ended. Otherwise, it would simply make the question answer very difficult to follow, both for the cross-examiner as well as for the tribunal.
Agreed.
Okay.
Thank you, sir. And just one other observation, because I understand that doctors are going to be presenting a presentation. Is that right? I do note that they have notes on their desk. We have no objection, of course, to them using notes during the presentation, but we would just ask that they not be consulted during any cross-examination.
Absolutely.
Thank you, sir.
So just hand over to you, Drs. Calvo and Langstroth, and if you could deliver your presentation.
Thank you. I will begin. We understand, about 5 minutes, so we will go down to the main points. There are 3 elements of context to then work up our conclusion. One is that the La Sola site is a wet site. It rains about 3,000 millimeters a year. That is almost double of the rainfall, the annual rainfall in Florida. It rains a lot, so there is a lot of water. Second, the site has a very particular topography. Imagine a sheet, a bed sheet that you drop down, and it has wrinkles, and there are furrows, and there are some flatter areas. The site kind of looks like that. That creates, for the purposes of our conversation regarding potential wetlands on site, 3 types of areas. There are areas where there is a gentle sloping area with a bottom area. The water can kind of sit there when it rains. There are some other areas, especially to the east of the site, where the wrinkles in the relief are sharper, and the water would tend to just flow quickly through there towards the aserradero system. And then the southwest corner of the site is more of a gently sloping area towards that corner and out of the site. Those general areas are the areas in question regarding whether there are wetlands or not. And third, the third context element is that, as we have heard this morning, there isn't a given methodology in Costa Rica, an operational way of going out to the site and determining if there is a wetland. Much of the way we will have to do it would rely on professional expertise. So with those 3 things as a context, I went to the site and I saw an area distinctly called Wetland 2 by Kevin Irwin, Depression 1 by Dr. Bailey. We call it D1, I believe. That is an example of a gently sloping area that forms a shallow bowl. When I was there in March, there was about 20 centimeters of water. The vegetation inside that flooded area was herbaceous grasses. And then there was a sharp edge. The slope goes up, and then there were shrubs and palms and a few trees. So that looks like a wetland. There's water, there's some plants that look typical. So what would we do to determine if there's a wetland? To use a systematic approach, we will have to go, say, to the center of the site, which is full of water, and do a, hopefully, quantitative analysis and determine if there is a preponderance of wetland plants, the hydrology, and then whether the soils are hydric or not. You do that in the center, and you start moving outwards until at some point you get to a point where you don't find those three characteristics, and somewhere in there you say, this is the boundary, the upland-wetland boundary. There should be a systematic approach in doing so. So I'm focusing more on the second report by Mr. Irwin and his team, and I read the methodology. And my conclusion is that a poor methodology results in unreliable results. You read the methodology, and all I find is we walked the perimeter of the target wetland. We took GPS points. We made a list of species, plant species. And we visually estimated the percent cover of each of the 108 species that they found. So imagine that I'm trying to do that on a potential wetland that is the size of a football field. How do I do that without a systematic approach? Walk around, it sounds like I already determined what the boundary is. So I walk it, I take GPS points, take a list, and I go, oh, that one species, 1%. The other species, 3%. In the text, there's nothing that tells me exactly how that was done. And yet, they have results that go very much into saying there are wetlands and there are these species, and they classify the species into wetland and wetland upland species and upland. The results do not follow the methods. And Dr. Langstroth now will talk especially about the species, the listing, the classification, and some of the observations we have about the species list. Robert?
Good afternoon, or good late morning. Yes, my discussion here is going to focus again on the findings of the botanical study, which is Appendix A of the second Casey report. The study, I believe, was prepared by botanists from CLCL. It is common practice, as we know, to utilize indicator species or utilize a classification of plant species based on their ecological tolerances to help establish criteria for delimiting wetlands. In the United States, there is an extensive database of plant occurrences, and there are statistical and probabilistic values attached to these categorizations. In the case of Costa Rica, as we know, there is no accepted national classification or categorization of wetland species. There are lists that have been published of plants that have been known to occur in wetlands, but there's no real equivalent classification system, which is fine. We shouldn't expect it to be necessarily. And I think, not incorrectly, the Costa Rica's wetland specialist that was consulted applied this methodology to the best that you can under the conditions. And so when we analyze the findings of the CLCL botanical report that was prepared from the second surveys from August and September of this year, we find a total of 108 species present within the areas delimited as wetlands. Again, in 3 days, a total of 28 hours in the field in August and September of this year. Out of those 108 species, we find that 38 are classified as upland species. Again, species that are associated with non-wetland habitats, species, especially long-lived plants such as trees, as we're familiar with. These can't persist in an area that is a wetland if they're an upland tree. You might find a seedling, you might find a sapling that might be there in a few dry seasons, but you're not going to find a mature canopy tree that belongs to a upland habitat in a wetland. It makes sense. Then there are 14 species that were identified as being strict wetland species, i.e. species that occur only in wetlands, and which we consider to be indicators of hydrophilic vegetation in accordance with the Costa Rican definition. Now, there are a larger number of species which couldn't be classified as either upland or wetland. So 56 out of the 108 species identified are species that could grow either in a wetland or in a non-wetland. Could grow in a swamp or can grow on a dry ridge top. And in the United States, when we utilize a USDA classification system, we have really 5 categories. And here we have 3. And so we're forced to kind of lump the species that in the United States would be a little bit more finely differentiated into obligate wetland species, facultative wetland species, facultative upland, and upland species. We don't know exactly where they fall within this 3rd category of wetland upland, okay? And for the purposes of this arbitration, this is very important because we're trying to make a decision about the presence or absence of a wetland. And again, based on the Costa Rican law, or Costa Rican legislation, we need to, again, have 3 conditions present. We need to have hydrophilic vegetation, we need to have hydric soils, and hydric condition. And so I'm focusing, again, simply on evidence to indicate a prevalence of hydrophilic vegetation. Next slide. And this is a summary of the findings of the various tables presented in the Appendix A of the 2nd CASE report. You won't find these numbers in their report because they weren't analyzed in this way. So what we have here, we have each of the areas that were delimited, which I'm calling P for polygon, simply an area defined by a bunch of points connected by a line. So we have these 8 polygons, and within these 8 polygons, we have data that indicate percent cover by plant species, by their ecological classification. And we have canopy, subcanopy, and ground cover. The canopy here are trees. Subcanopy are small trees or shrubs, and the ground cover are herbaceous plants, grasses and sedges and other small things, okay? And so when we look at these data, the first thing that's apparent is we don't have a single wetland tree present on the site, which is interesting, okay? So canopy cover for W species is 0 across the board. Subcanopy, we have varying levels of cover by what's indicated in their classification as a wetland species. It's a single species known as Mimosa pigra, which is a highly invasive leguminous shrub, a very prickly plant that grows in a wide range of habitats. It indeed does very well in wetland habitats, absolutely. But it's also found in, as a weed in rangelands that are not wetlands, in palm plantations and various sorts of agricultural situations, it really shouldn't be considered a strict wetland species, based on my experience working in Latin America for more than 30 years in numerous tropical countries. I know this plant very well. And so, but even if we take it at face value, as presented here, we find relatively small degrees of cover, ranging from 0 in a few cases. In one case, we have up to 30% cover by this plant. In terms of the ground cover, we see relatively small numbers again in terms of ground cover, percent cover by strict wetland species, ranging from 0. In 2 of the areas purported to be wetlands, we actually have no cover by a strict wetland herbaceous species. In one case, we have, you see a big number there, you see 60% cover by a wetland species. This is the case of a small floating aquatic plant of the genus Lemna, commonly known as duckweed. And duckweed is an aquatic plant, and in this particular situation, this 60% cover corresponds to a ponded area along the highway to the north of the site, where drainage has been impeded by construction of this road years ago, and it fills up with water. But beyond the duckweed, there aren't any other strict wetland species in that site. So overall, we're ranging from 0 to 14% coverage in strict wetland species in all the remaining delineated areas. And again, you know, the percent cover by upland species is often higher than the cover of wetland species in these areas. So it's really not very conclusive evidence. We certainly don't see any sort of a preponderance or dominance or prevalence of documented, well-known obligate wetland species. And as I will point out further, the WU wetland or upland plant classification as used here really can't be considered conclusive evidence for a wetland. Next slide. And so just some examples of species that we have picked out, in part on our own, from our own background, and in part due to critiques of our first report. We'll go through these quickly. Okay, what we did was, where possible, we fact-checked the references that were used by the CLCL team in order to develop these classifications. And we acknowledge that utilizing published floras, published lists of species, plant manuals, et cetera, is established practice. And so here we are citing the Flora costarricensis, which is an established authoritative source by the Field Museum of Natural History. And it says this species here is a tree of deciduous, partially deciduous, and lowland evergreen rainforest formations. Again, no mention of wetlands here. Next. One other species that's been indicated as a WU species is in fact the national tree of Costa Rica and sort of the prototypical dry forest species of Central America, the Guanacaste tree. Also not a species that anybody would think as an indicator of a wetland. Next. A plant that's been discussed in various documents, a weedy grass of the tropics, native to the neotropics, but expanded around the world. Again, something you'll find in many, many situations, can be common in wetlands, but can be common in non-wetlands. Next. Now, there was some discussion in our previous report about 3 genera of plants. Costus, you just go through these, save time, Calathea, and Heliconia. Next one. And I was criticized by considering these not to be wetland plants in the sense of being strict indicators of wetlands. These are plants, both in species and in genera level, that occur in a wide range of habitats. Wherever there is sufficient moisture, again, you can find these plants in wetlands, but you can find them just as well in a shady spot under a forest canopy where there's humidity, or, as in the case of this particular species, which was one documented from the wetland, this is actually a species that is well known to occur in areas that are secondary open sites because of its ability to tolerate drought. And this is, pardon the German here, but that was a good source. And so, based on this quick review, again, in the essence of time, we find that basing a conclusion of wetlands on these W species is a perilous enterprise. Also, furthermore, I simply want to point out that in the text of the KC report, in paragraphs 18 through 25, there's a bit of confusion on the use of these classifications. We find the KC report itself grouping together the wetland species plus the wetland upland species and stating these to all be wetland plants, which we disagree with strongly. And again, in conclusion, the data provided by the report does not permit us to make a decision that we have a dominance or a prevalence of any sort of hydrophilic vegetation in the areas delimited as wetlands. Thank you.
Thank you. No questions.
Thank you. Mr. Leatley?
Thank you, sir. And just one observation, if I may. We have a hard copy of the presentation, but we seem to be missing some of the slides from that presentation. So if I could request at some point to get a complete copy, that would be helpful.
Especially the last slide I didn't identify in practice.
Thank you. Good afternoon, gentlemen.
Good afternoon. Now,
Drs. Calvo Langstroth, you've prepared a single report for this arbitration, finalized on the 28th of July 2016, is that right?
That is correct.
And you both work for ERM, although your report doesn't bear any ERM logo, is that right?
That's correct.
Is ERM aware that you produced this report?
Yes, they are.
Okay. Is there any reason why it doesn't bear the ERM logo?
None in particular. I'm a partner at the company, and I produced a report. Robert helped review it, and we just are acting as experts in this arbitration. It just so happened that we work for ERM.
It just so happens you work for ERM, but is this an ERM report?
You could say it is, yes.
Why would you qualify you could say it is?
Because we have been working, the two of us, on this arbitration without help from other partners, for example. And but the agreement, the commercial agreement to do this work was through ERM.
Okay, thank you. And Dr. Calvo, you visited the property on the 6th and the 7th of July, is that right?
That's correct.
And Dr. Langstroth, what has been your contribution to the report?
my contribution has been the review of selected documents that provide information on the plant species present or identified as being present at the site.
Thank you. And in your report, you testify that you conducted an assessment of the environmental conditions in the Las Olas project. Is that right?
That's correct.
And you state in your report that the scope of your report was to determine whether there were or has ever been wetlands in the project site. Is that right?
That's correct. And I did 2 days on the site, and I did a reconnaissance of the site conditions.
And you also say that you attempted to determine whether there were or has ever been a forest or trees protected by Costa Rican law in the project site.
That's correct.
Right? And you say that for the purpose of your report was to determine whether the claimants caused any harm to those protected trees and forests. Is that right?
Would you show me where I say that?
Yes, this is paragraph 1 of your report. I need this. Paragraph 1D.
Yes, that was part of the original language of the agreement, the expert witnessing agreement. As you can see, I believe, through the rest of the report, we really don't go there in our discussion.
I noticed that, sir. So your report actually doesn't take any position on whether or not harm was caused by the developers?
That is correct.
Okay. and you're aware that the claimants have owned the land since 2002,
That's correct.
which means your report, if I understand it correctly, is summarising the behavioural patterns for 38 hectares over a period of 14 years. Is that right?
Our report is based on two main things in terms of this question.
Yes.
One is the observations on the visit that I made, the review of Kevin Irwin's reports, and the review of the aerial photography.
Understood, sir, but just going back to paragraph 1 and looking at the scope of your report,
Yeah.
you're talking about whether the site contains or ever has contained wetlands.
Correct.
That's the scope of your report, is that right?
Yes.
And you do that in 13 pages
Yes, it was
For-
a short report.
for 14 years.
Yes.
Okay, thank you. With 2 photographs
Yes.
and 5 Google Maps covering 2002, 2012 and 2016.
That's what the report contains.
Just 3 years. Is that right, sir?
Yes,
For a period of 14 years.
that's correct.
Okay. And based on one conversation with a neighbour, as I understand. Is that right?
The conversation with the neighbor was part of the visit, and we had several conversations. And in that particular case, that conversation was regarding some past condition of the site.
Mm-hmm. And this is a neighbour who the claimants introduced you to. Is that right?
Yes,
Right. And you didn't conduct a soil survey, did you? You say that openly in your report.
I did not.
So whatever you found, in the absence of a soil survey, you were never going to be able to say there's definitive evidence to find a wetland, were you?
We say in the report that we found evidence of some potential characteristics of wetlands, but we did not complete a soil survey, and therefore we cannot conclude definitively.
Right. So do you consider that a fair or reasonable approach to define the parameters of your investigation such that you could never conclude that there was a wetland?
Could you repeat that question?
Yes, sir. Do you consider it fair or reasonable for you to define the parameters of your investigation such that you could never conclude that there is a wetland?
We were not trying to determine if there were wetlands.
That's not what you say in your report,
Under
sir.
the 3 parameters. We had one visit for 2 days,
Mm-hmm.
and we completed observations regarding vegetation and some of the hydric conditions, but we did not complete the soil analysis.
Right. So let's go back to the scope of your survey. Your scope says whether the Las Olas site contains or has ever contained wetlands. And to do that, you needed to have a soil survey, which you did not do.
Which we did not do.
So you could never, in any version of your report, have concluded that there are wetlands. You were tying your own hands on that conclusion.
On reaching that conclusion, you can say that.
Right. Now, the only tool... Actually, sorry, sir. Excuse me one. Could you please, and I leave it open to who answers this question, could you please explain to the tribunal why wetlands are so heavily protected, both in Costa Rica and worldwide?
I can begin and answer and let Robert continue.
And apologies, I will interrupt you at some point, so I'll give you advance notice I will interrupt you, but it'd be not
So
interesting
you will
to hear.
interrupt me.
I will interrupt you. I'm giving you a warning that I
Fair
will.
warning.
Thank you.
In general, wetlands are recognized as having important ecological functions, including attenuation of floods, repository of biodiversity. They have been recognized, and both individual countries around the world and the international community have both found and created legislation and rules and agreements to protect wetlands. Robert, you want to add?
Right, and of course, we're all familiar with the Ramsar Convention, which is in part the origin of some of the language in some of the Costa Rican legislation. The Ramsar Convention was something signed in a town called Ramsar in Iran back in 1971, and its intent was to urge the countries of the world to identify wetlands of international significance and to contribute wetlands from their countries to a list of wetlands of international significance, which we talk about as the Ramsar list. We talk about Ramsar sites.
And sorry to interrupt you there, so it was more about the ecological significance. So why are they so heavily protected? I understand the Ramsar Convention, and we may come to that, but more in terms of the ecological, as Dr. Calvo was beginning to explain, would you agree that it helps with the generation and the preservation of soils? With the pollination of crops, you were talking about the biodiversity, that maintains biodiversity. Would these be all?
In general, wetlands
Yeah.
have functions, some more than others. Some wetlands, thinking about Ramsar, are very important because of their extension, their biodiversity value. Other wet areas or even wetlands may have the three parameters, but they may not be that important or sensible or sensitive in terms of their ecological value.
Understood. Thank you. And so would you agree with Mr. Irwin when he describes in his report the environmental significance of a wetland?
I agree, I think we both agree with the conceptual description of the general value of wetlands.
Thank you. And would you agree with the assessment that once you destroy, you could cause irreparable harm to a wetland?
At face value, yes.
And therefore, would you agree with a gentleman who's appeared during the course of this week, Mr. Musio, who's the architect, who had testified that you cannot leave things to chance when identifying a wetland?
I agree that if you are to identify a wetland, you should follow a methodology that is well put together.
And presumably there's a need to be particularly sensitive to these ecosystems because of their inherent sensitivity. Is that right?
Again, some wetlands are very sensitive. Other wetlands are little more than weedy, wet areas.
Right.
So it's relative. Not all wetlands are created equal.
Understood, sir.
Yeah.
And so we're obviously in the world of Palestrine wetlands. Based on the sort of the ideas of protection, would you agree that if there is evidence of a potential wetland, that it should be taken seriously?
We'd agree. If there were evidence of a potential wetland, it should be taken seriously. We certainly agree with the importance of Costa Rica's right and obligation to protect wetlands of high biodiversity value. And again, as you know, wetlands vary, as pointed out by Dr. Calvo. And so when there is a potential for the identification of a wetland, it is certainly very important that that wetland be thoroughly examined and that its boundaries be thoroughly delimited based on the criteria applied in the particular legal situation, in this case Costa Rica, in this case the Minay Decree, that establishes, again, 3 essential criteria that all 3 must be present in the place. The presence of the soil and the presence of water.
I'm sorry to interrupt you, sir.
Again.
We'll come on to that.
Very
The
good.
question was slightly different.
Yep.
But just returning to you, Dr. Calvo, the Ramsar Convention nor Costa Rican law makes any difference between what is seen as a valuable wetland or not, right? They just protect wetlands.
As I understand it.
Right, thank you. Dr. Langstroth, you say in your report that you review the areas identified in the Casey report that Casey identifies as wetlands. Is that right?
That's correct.
And Dr. Calvo, you took a couple of pictures of the areas that you walked. Is that right?
That's correct.
And was it just 2 pictures?
I took a few more.
Now, those aren't in your report, are they?
They are not in the report.
Were they shown to Dr. Langstroth?
Yes.
And he reached a conclusion based on those photographs?
A conclusion
I'm
regarding...
sorry, Dr. Langstroth, you reached a conclusion based on those
I
photographs?
reached a conclusion based on in our first report, obviously I based a conclusion based on all of the available information, which was not simply Dr. Calvo's report or photographs. As you are well known, there are hundreds of documents entered into this case, including reports going back to 2008, 2010. There's a lot of information that,
Understood,
that
sir.
we reviewed. So,
And I'm just interested in what's in your report. So in your report for this tribunal, you include 2 photographs, but you don't include the other data that you
That's
have.
correct. And let me clarify the preparation of the report. I was the main author of the report. Robert reviewed it for me, and we talked about it, but I wrote the report.
Now, you haven't included any other records of the areas that you visited in the property. For example, we understand from Claimants Council that you did not use or create any KMZ files.
I
Is that
did not.
correct? Would you mind explaining for the benefit of the tribunal what is a .kmz file?
In layman's term,
Ideally, sir, for me as well. Yes,
Yes.
that would be helpful.
basically those are files that have geo-reference points that can be placed on top of typically, and more used lately, a Google Earth map, for example.
Thank you. And so, Dr. Calvo, you were walking around the site with no means of accurately verifying where you were when you were making your observations.
Not on a geo-referential fashion, correct.
And you expected Dr. Langstroth to verify your findings without such data. Is that right?
Let's describe what the findings are, and as we were doing them.
We'll come to that in a moment. I'm interested in your methodology that you said was very important. Your methodology was you didn't take any geo-satellite data plotting, and therefore Dr. Langstroth would have been unable to identify where you were when you were making various observations. Is
Dr.
that right?
Langstroth was not commenting on whether there were wetlands or the extent of the wetlands. He was concentrating his research and his review on literature review of some of the species that were listed by Kevin Irwin's reports, and we talked much about the meaning of this species and that species, but he was not in the field, and he did not intend or pretend to verify the extent of wetlands.
Understood. Then, Dr. Langstroth, your contribution, as you said before, was about some of the vegetation. And so you were not given any GPS or any data to confirm the observations that were made by Dr. Calvo as to where they were made. Is that correct?
my role in the
I'm
initial
sorry, sir, it's a
report,
simple question, whether you were given data.
I was given data. Yes,
So you had KMZ files.
I have. Again, my role was not to evaluate Dr. Calvo's data. My role was to evaluate data presented by Costa Rica to identify wetlands. ERM was not hired to do a wetland delineation. It was hired to examine evidence, which is including photographs taken by various individuals, again, examining satellite imagery, aerial photos, species lists. There was lots of evidence that can be taken into consideration, not simply what was collected by Dr. Calvo.
Understood. No, sorry, sir. I want to ask Dr. Langstroth another question on this. You have testified to this tribunal regarding an array of vegetation, which you do not have first-hand knowledge of because you didn't visit the site. Is that correct?
I have first-hand knowledge of many of the species that
No, sir.
are
I'm
listed.
talking about the site, sir.
I have no first-hand knowledge of this particular site. That is correct.
So the data set that you were being provided to analyze the vegetation was not something that you could have oriented to somewhere specifically on the land. Is that right? Because you did not have the plotting location.
I'm not sure which data set, again, you're referring to.
Okay, let me make it a little simpler, sir. If I asked you now to walk to this site and tell me where a certain vegetation is growing, which you have identified in your report, you would not be able to take me to that specific location, would you, sir?
I disagree, sir. I'd be happy to do so.
How would you accumulate that data?
Because I have all of the KMZ files that were presented by the KC team, and that is the basis upon which the determination of wetlands on the site is to be made.
But
So-
you don't know, because Dr. Calvo didn't plot it, when Dr. Calvo made an observation, what he's referring to. There's no way Dr. Calvo could have identified a specific KMZ location, because he didn't have that equipment.
That's correct. However, it does not bear upon any of my conclusions.
Can I clarify on what we did, which is relevant to the question?
Yes, please go ahead.
I did not even create a wetland list when I was there. I walked around, I saw and gathered in a reconnaissance type evaluation. I gathered a general impression of the site. I recognized many of the species, and if you look at our report, we indicate that Casey, both in the first report and now that we know the second report, they did develop a list of species, and we do not dispute the list of species. So we accept that 97 species in the first report, then the second list was 108 species. We accept that those species are on site. So there was no information on the location of specific trees or shrubs or herbaceous plants that I created that then Robert would have to either accept or not. So I did not do that.
Now, Dr. Bailey conducted a soil study, and you were aware of that. Is that right, before you prepared your report?
I knew that Dr. Bailey was doing that, yes.
And Dr. Bailey's report is dated the 31st of July, and your report is dated the 28th of July. Is that right?
I don't know what date his report is, but if you say so, I believe it.
Did you review Dr. Bailey's soil report before issuing your report?
I had an early version,
Yes, yes.
and I went through it. But
Okay.
I wasn't looking at soil, so I didn't study the report in any level of detail.
So you didn't think it would have been prudent to wait a few more days until you had a soil report in order to incorporate what you on your own testimony in your report said was the principal deficiency of being able to conclude that there is a wetland?
The way we interpreted that, Robert and I talked about this, was we will concentrate on what we're good at, and we would let the soils expert concentrate on what he's good at.
So let's go back to the scope of your report. You're saying whether the Las Olas project site contains or has ever contained wetlands protected by Costa Rican law. You could not do that in the absence of a soil study. Is that correct?
And we do not say whether there are wetlands or not in our report either.
We'll come to that in a moment. I wonder if you can go to page 3 of your report. Can you please read the title of this section? This is at the top.
Topography and high precipitation.
No, sorry, sir. Above that.
Are there wetlands on site?
And that's a question, right?
Correct.
Now please turn to paragraph 37 of your report. Do you have that,
Yes.
sir?
Yes?
And you say, in conclusion, the 3 depressional areas located on the west and northwest sides of Las Olas site show characteristics of a freshwater marsh and are potentially wetlands. Is that right?
I say that.
And then it continues about the dominance of Mexican crown grass, evidence of seasonal flooding, and then you talk about soils.
Yes.
And I would just merely invite the tribunal to put a little scribble next to paragraph 37. I won't read it in totality here. Now, you refer to the definition of wetland under Costa Rican law, I assume?
There is a section in which we summarize the definition, yes.
In fact, let's go to paragraph 30 of your report.
Yes?
And here you refer to the Ramsar definition and how wetlands are areas of marsh, fen, peat, and or water. And then it continues a little more, which includes static water. You see that, sir?
I do.
And then in page 4, paragraph 19 of your report,
Yes?
you include a photograph that is titled Standing Water.
Yes?
And then on page 5, paragraph 23, you include a second photograph which shows the extent of the Mexican crown grass, which is a plant associated.
It is a
with
sharp
wetland.
vegetation edge
Sorry, sir.
indicating the boundary of flooding.
I'm sorry, I need to finish my question. I
Oh,
apologize.
yes. Sorry.
I appreciate the willingness to answer, but let me finish my question. So this is a Mexican crown grass, which is a plant associated with wetlands. although, as you say in paragraph 37, it's not determinative in and of itself of wetlands. Is that right?
I do say that.
And Dr. Langstroth, I saw you nodding. Would you confirm that as well?
I agree. That's correct.
Thank you. So we have evidence indicating that in the 2 out of 2 elements under Article 6 of the Minai Decree, there are signs potentially indicating wetlands. Would you agree?
Potentially.
Thank you. Now, let's go to your conclusions at paragraph 75 of your report. We're going to put paragraph 37 and paragraph 75 up on the screen. Why do you delete the reference to there being potentially wetlands from your conclusion?
Between 37 and 75?
Yes, sir.
Let me see. I don't recall. I just wrote the conclusion in a more specific way, I guess. But I don't recall that I removed the potentially wetland words for any particular reason.
Well, the wording is identical, but for the conclusion
Yeah.
that says there are potentially wetlands.
Yes?
There's no reason why you deleted that.
Not that I
final
recall.
wording.
Gives me the answer again.
None that I recall.
Thank you.
Did you delete it, sir, because you felt it was obvious based on the other conclusions you had found? You found a marsh or a swamp, static water, vegetation associated with wetlands?
I don't recall why I deleted it.
Do you think it should remain in the conclusion, as per paragraph 37?
It is already in the report, so it could be in the conclusion, yes.
Can we turn to Article 5 of the decree? This is decree, the Minai Decree, tab 2 in your binder.
I would let Robert look at that.
Of course,
portion,
yes,
if
please. I
that's okay.
would like you to both be able to see what you have.
Yeah.
Apologies, we don't have 2 copies. That's our oversight.
Tab 5.
Have you looked at this before?
Yes, I have.
Now, in the Spanish version, it reads definiciones, and then it defines each of the 3 factors. Is that right?
That's correct.
And Dr. Langstroth, I just wanted to confirm you read Spanish?
I do.
Great, thank you. And can you go to the section, subparagraph B, where it says suelos hídricos, hydric soils?
Okay.
And can you just read, this is already on the record, so maybe you can just take 2 seconds to read that for yourself, sir.
Okay.
And so this is saying that hydric soils is defined by reference to hydric soils and hydromorphic soils. Is that right?
Hydromorphic soils, as used here, apparently is a synonym in this particular definition, as used in Costa Rica. It
Thank you.
appears. That's correct.
Thank you. Could you please go to paragraph 16 of your report?
$16?
Yes, sir.
Yes.
Now, I'm going to read the second and the third sentence here. It says, there is a series of small hills, mainly on the north and central portions of the site. Moderate slopes into lower areas create natural drainage features on the north, east, south, and west of the site. Do you see that?
Yes.
And then there's a description of the topography of the site in order to determine whether there are wetlands. Is that right?
A description of the topography of the site.
I'm sorry, so this is a description of the topography of the site.
This is a description of the topography of the site as it relates to how the water would move through the site.
And this description was based, Dr. Calvo, on your observations at the moment of the site visit. Is that right?
They were based on both my observations when I was on site and then the review of the topo map from the Museo Madrigal drawings.
And you refer to the 2008 topographic map of the site prepared by Museo Madrigal, but you say expressly in this paragraph 16 that you did not use it for your analysis. Is that right? Last few words of paragraph 16.
Yeah, we say we used it as a topographical map, only as a general reference of the topo characteristics, but did not use it for our analysis. So yes, we say that.
And you don't exhibit it to your report either, do you? You
We don't add it into the report?
Yes, it's not attached or appendix to
I
it.
think there was a figure that may have the topography on it. Perhaps? Don't recall. No, there isn't.
That's also my understanding.
Yeah.
Thank you. Now, please, could you go to paragraph 19 of your report?
Yes?
And here you're describing the current topographical conditions of the southwest corner of the site. Is that right?
Yes.
And you testified a moment ago that in fact, you say this in paragraph 1b of your report, that the objective of your report was to determine whether Las Olas project site has ever contained wetlands, correct?
Yes, we'd say that.
But although you had to determine whether there ever had been wetlands on the site, you based your findings solely on the conditions of the site based on your visit on the 6th and the 7th of July, correct?
And, yes, and on the review of the historical photography from 2002.
In 2002.
And on, yes.
Well, from and on, you mean 2002, and then 2012 and 2014.
Correct.
So there was a gap of 10 years there.
Yes.
And you did not use the 2008 topographical map, did you?
The description here, for example, 20 meters above sea level, down to 10 meters above sea level, are connecting what I saw with the altitudes indicated in the topo map, because I could not determine the altitudes on site by myself.
Now, please, can you go to the aerial photography 2005? This is figure 4 of the second KC report, which I believe is behind tab 3.
Okay,
Do you see that, sir?
I do.
And on the southwest side of the property shows a large depressional area at or below 10 meters. Would you agree with that?
That's what the map says, yes. You can see in this map, but I have seen it in the larger version map.
And you state in paragraph 19 of your report that you observed in the southwest side a, quote, gently sloping area, close quote, with elevations decreasing from adjacent hills of more than 20 meters to the south portion of the site at about 10 meters. Is that right?
That's what I say.
But you do not address this change and any possible cause of this change in your report, do you?
What change?
Well, any change that is being alleged in this arbitration regarding the fill of the potential wetlands?
No, I don't address that. I'm referring to the observation of the gently sloping site, which I could see from where I was standing. And then looking at the topography map, I could see that the elevations, according to the topo map, were moving from 20 meters down to 10 meters and out the site.
And you don't identify anywhere in your report any analysis or assessment of the change that Mr. Mora, the neighbor, is telling you took place?
The only comment that he mentioned that I referred to in the report is that in the past, before anything happened on that site, the water used to flow out of the site, straight down the road to the sea.
Mm-hmm. And you don't do an independent assessment of that change?
I
at all,
did
do
not.
you? So your report's a snapshot of the site in July of 2016, essentially?
Plus the understanding gained after looking at the 3 time series photograph.
Right. And so, based on a photo from 2002 and then a aerial photo from 2014, you are determining whether there ever has been wetlands on the site. Is that right?
Yes, and I can explain the observation on the 2002 and why we feel that way.
We'll come on to
Robert
that.
reviewed that too.
Very good. We'll come on to that in a moment.
Okay.
Now, did you review the work papers or any documentary evidence from the construction at the site?
I did not.
And did you review or speak to any construction companies or employees who'd been employed at the site?
I did not.
And did you review any photographs of any construction works that had occurred at the site?
The only photographs I've seen that discuss construction and fill and things that have been done on the site were those from the Casey reports.
Okay, thank you. Do you think that those sort of information that I've just described would have been helpful for you to determine whether there had been any change to the land?
And I don't dispute that there were changes to the land, and yes, I understand that there were changes to the land.
Right, but your job, sir, if I may put it this way, was to assess the nature of that change, the cause of that change, but you have no way of understanding whether either change occurred yourself or what was the reason for that change.
I understand the reason for the change in that I have read information and seen pictures of works that have been carried out on what is called Wetland 1 by Casey.
That's not what you just testified,
plus
sir.
the observation from the area photos.
Well, so you've just contradicted yourself within the space of about 30 seconds. You just told me you hadn't seen photographs and you hadn't seen evidence regarding the works or the construction. So is it now your testimony that you have seen photographs?
I believe I said, and the transcriber can probably tell me if I'm wrong, that I had seen, the only pictures I had seen of works that have been carried out on site were those in Casey's reports 1 and 2.
I see.
So
I
that-
see.
that-
I
that
beg your
I
pardon.
have seen.
So that's your data set was from Casey's report.
That's my observation.
And so there was no independent assessment or verification yourself?
No.
I hope that doesn't mean my time is up. So. So your report doesn't analyze any of the potential filling or the draining of Wetland 1, does it?
Not directly, not.
Okay, thank you. I wonder if you can turn to figure 5 of your report, please.
Of our report?
Yes, sir, your report.
Oh, you have it right here. Okay.
So that will be behind your report at the front of the cross bundle. Now, gentlemen, you identified 3 depressional areas near the northwest and west corner of the property. Is that right?
Correct.
And you can see that these correspond, and I think we're going to put this up on the screen so you can compare with Casey's report. KC5 would correspond with Depression 3. KC3 would correspond to Depression 2. And KC2, Wetland 2, would correspond to Depression 1. Would you agree with that?
Yes, I do.
And they're also referred to in Dr. Bailey's report as Bajos B2, B4, and B6. Would you generally agree with that?
Yes.
Thank you. Now, let's turn to paragraph 34 of your report, please. And here you say, based on field observations and document review, the 3 depressional areas located on the west side of the Las Olas site show some characteristics of wetlands, as defined in the Costa Rican regulations. However, without soils analysis, we cannot confirm whether these are in fact wetlands. And by some, you meant 2 out of 3 conditions, correct?
We refer to vegetation. We talk about Mexican crown grass, which we have mentioned several times. And we clarify that its presence by itself is not enough, but certainly it's something happening there, so we stipulate to that. And then the site was flooded when I was there, and it rains a lot there, so there's probably water that sits there for lengths of time. So yes, those two characteristics we discuss here.
Thank you. I'd like to take you to the Bailey report, sir. You mentioned you'd seen previous drafts. Am I right in thinking you'd seen the final draft?
No, I never saw the final draft.
Okay.
Okay.
And I wonder if you could go to paragraph 6, please.
6.
Yes, sir.
Okay. Now, this is a Spanish version. Is that the right one?
Oh, I'm
looking at?
sorry.
It's okay. I mean, I can read either language. But just want to make sure that we're on the same page.
I'm
literally.
confused who speaks what these days, sir. So the translation should also be there, hopefully.
Yeah, I'm reading in English now. Okay.
Paragraph 6, I'm going to read it. It says, 3 of 6 valleys have glade soils, understanding water and qualify for class 7 or 8 in the land evaluation system of Costa Rica, and as hydric by the criteria of MINAI. 2 of these valleys are very small, and the other is less than 1 hectare. Works by the investors have not significantly affected these soils. And then I wonder if you can look at figure 5 of the Bailey report. It's on page 27.
27. Okay. That's when I can never get there. Yes.
You have that there, sir?
Yes.
So therefore, these 3 depressions can be considered wetlands because they have met the 3 requirements contained in decree of the MINAI decree that you mentioned in paragraph 33. The 2 conditions.
I do not agree with that. As we have looked at more details, especially now with the second case report and the more specific and yet deficient analysis of vegetation and cover and things, even the vegetation criteria is a little iffy, so I'm not convinced.
You're not convinced, but you've identified in your report hydric conditions and vegetation that could be indicative of wetlands.
Correct.
And Dr. Bailey, the soil expert, has identified hydric conditions. So help me out, sir. If we have the 3 criteria, why are you able to then say there are no wetlands?
In our report, when we made that conclusion and discussed that element, we also clarify that Paspalum fasciculatum by itself, which is by far the dominant species, based on what I knew at the moment and the first case report, is not sufficient to make sure or be sure that the vegetation is hydrophilic.
But the Papasalum, the Mexican crown grass, can and does, in certain circumstances, grow in wetlands, correct?
It does. It also grows in non-wetlands.
Understood, sir.
Yes.
So for you, the glass is half empty, and for me, the glass is half full. Would you agree?
I'm not talking about glass, water in glass.
No.
But we have different interpretations.
We are in
Yes.
agreement, it seems, that Mexican crown grass can potentially and does, in reality, grow in wetland areas. And your testimony, which I don't think is disputed, is that Mexican crown grass can potentially and does grow in non-wetland areas.
That is correct.
Okay, thank you, sir. Now, you were shown 3 site plans by the claimants when you prepared your report.
Yes, when I was in Costa Rica, I had 3 large-size printouts.
Now, 2 of them are behind tabs 9 and 10 in your cross-binder.
Okay, 9 and 10.
Now, Dr. Langstroth, sorry, I'll give you a chance just to get to them. Just have a quick look and see if you can remind. These were provided members of the tribunal last night. I'm losing track of time now, but I think it was last night by Claimants Counsel. Could you just confirm if those are 2 of the three plans that you had seen?
I cannot read the fine print because it's too small, but the name of the file, L48 and L49, as of what I saw last night, do correspond to two of the three drawings that I had seen.
Okay, thank you. Now, Dr. Langstroth, you did not review these three plans, did you?
That's correct. I did not.
Now, in paragraph 41 to 44 of your report, you refer to those site plans.
Correct.
And you say in paragraph 44 that the areas of depressions are outside the development areas, in the easement areas. Is that right? I'd just like you to read what paragraph 44 says.
What I say in paragraph 44 is that the site plan, which is the third drawing that is not quite here, but I can comment on that drawing, generally, and that's the wording I use, generally avoiding encroachment into depressions D1 and D3, which corresponds to wetlands 2 and 5.
Right, thank you. And your point is that even if there were wetlands on this area, the fact is that there's been no development on those areas means that it's less of a concern to you, essentially.
The point was that those areas, for whatever reason, the master planners found appropriate to basically avoid with lots and other construction of structures.
And so, with your environmentalist hat on, that would give you some comfort that accommodation is being made of these areas. Is that right?
Yes. And also, I would add that these areas also represent natural drainage areas where the water would flow into. So, from the master planning work that I have participated in the past, you take advantage of that type of feature to make sure that the water runs in the right direction.
Okay, thank you. Now, I'd ask the tribunal to keep a thumb or a pen or a piece of paper in those two maps, because we're going to do a little exercise of compare and contrast. Please take a look at the image which is now on the screen. This is the master site plan from September the 17th, 2008. This, for the record, is C54. Do you see that, sir?
I do.
Now, this is Mr. Mucio's master site plan. And you can see in the left-hand corner, the bottom left-hand corner, the name of Mucio Madrigal. This is the architect's name, the firm name. Is that
Yes.
right, sir? Bottom left.
Yeah.
And just to be clear, sir, C54 is described by the claimants in their memorial, paragraph 84, and I just do this for the record, if I may, as, quote, the master site plan, which would later be used to apply for the environmental viability for the condominium section of the project. I'm not asking you to comment on that, sir, it's just an observation. But I'm now going to put this master site plan over your findings of your findings and those of Dr. Bailey and Casey. This, for the record, came from the opening submission during the presentation. And so there, sir, you can see the master site plan sitting on top of the findings that have been located by you, by Casey, and by Dr. Bailey. Would you agree with that?
It seems to be, yeah. First time I see it, but it looks that that's what you have done.
Now, let's look back at the maps that you had at L48 and L49. So you took comfort, sir, from the plans that you were shown at the time when you visited Costa Rica, that those L48 and L49 plans were accommodating the areas that you had identified.
I did not take comfort. I just made the observation that the plan generally avoided encroachment into those areas.
Thank you. So let's go back, Mike, to the other illustration we just had with the master site plan? And can you see the proposed construction over those areas?
I see the lots, the streets, and what seems to be lots on the easement areas as well.
So would you agree with me, sir, that based on this document, which is the master site plan, that there would be development and construction over these areas that you, Dr. Bailey and Casey, have identified?
Seeing from here, it appears as if I think those are lots on the yellow area in the easements, I guess.
You're aware of the easement, sir?
Vaguely. I don't understand the legality of the easements.
Okay.
But it seems to show lots, perhaps, in there.
Let's go to another map, sir. This is a map that Mr. Musio exhibited to his witness statement. This is tab 13 in your bundle. This was the last page of Mr. Musio's statement. Are you familiar with this map?
No, I've never seen it.
Now, would you note, sir, or would you agree, sir, that the claimants here were also proposing to construct over one of the areas that you had identified? Area number 1?
At this scale, it's hard to see.
Would you agree with me that it's... Well, let's go back. Mike, let's go back to the... So you see the areas identified there, sir?
Specifically to that area next to the road,
You see the top left? So it's the highest point in the entire map.
I can see the area that you're referring to. I mean, I
Yes.
know what you're talking about.
Yes.
But at this scale, I really have a hard time telling what's going on in the map.
Let's go back to the
I mean,
Mr.
looking at the
Musio's...
printout,
Yes. Well, okay. Let's
not
go back
sure.
to Mr. Musio's map. You see
Yeah.
the angle of the orientation of the land is slightly different, but would you agree that the top left sort of, it's almost like a fork, but the top left prong, where there's a number 1 in a circle, that's identified by Mr. Musio as a sensitive area.
I don't see it clear enough to understand exactly what's on that circle, number 1.
But can you see underneath it that there's construction proposed?
That's what I'm saying, that I don't see it clearly enough to know what's there.
Okay. And I wonder if I can just make one clarification. We'd like to show you now a document which is C222. This is behind tab 14 of your report, of your bundle.
Okay?
Now, this is in actual fact the plan that was submitted with the D1 application. Are you familiar with the concept of a D1 application?
Vaguely. I understand that it was a form that is used to apply for a permit, I believe.
And so this was submitted, but this notably removes the easements because it was for the condominium section. I don't ask that as a question. I think it would be unfair to put that as a question to you, but I just make an observation for the record.
Okay?
In paragraph 76 of your report, you testify that in the southwest corner, which is KC Wetland 1, I'm sorry, sir, I've forgotten a question I intended to ask you. Going back to Mr. Musio's plans.
Which is under 14. Found it, okay?
I just want to be clear on your testimony. The 3 plans that you were shown include L48 and L49, and then one more. Is that right?
Correct.
Okay, thank you. Now, in paragraph 76 of your report,
Yes?
you testify that in the southwest corner, which is KC Wetland 1, there is not a wetland. Is that correct?
That's what we say.
Of course, this is the wetland you say in paragraphs 35 and 76 is the subject of the dispute in this case, correct?
I understood that there is a dispute around the filling and construction of the area or something.
Although you're aware that there are other wetlands identified by Casey in Mr. Irwin's study, correct?
Yes, sir.
Now, were you told that the dispute included the allegation of filling wetlands?
Was I told? I read it in some document.
So you were aware before the time of your report that there was an allegation of a filling of the wetlands?
Yes,
But you don't mention the word fill anywhere in your report,
I don't.
and you don't analyze the prospect or the possibility that there was filling anywhere in your report.
Besides the discussion we had earlier regarding seeing pictures of the work from Casey's report and reviewing the historical photography.
I'm sorry, sir, I'm just checking which questions remain for me to ask. Thank you. I don't have any further questions.
Okay.
No
Mr.
questions, sir.
Mr. Mark?
Just one. As I understand the basic conclusion that you have reached, it is that you defer essentially on the final question of wetlands to the soils experts, that you have provided us with evidence that shows that the chart of the plants that could be used to characterize wetlands or non-wetlands, but that the final determination rests with the soils expert. Is that correct, an understanding?
It is partially correct, sir. Since we wrote this report, we also have now seen the second Casey report. So there are two sides to what we are looking at. One is that on the site, particularly those shallow areas, there are some suggestive characteristics of wetlands. We are not convinced that Paspalum fascicularum really answers the question from the vegetation side. We did not attempt to answer the soil side. So in that sense, yes.
Right, so my understanding is correct then, that it's an indication of the plant life. It's not dispositive, but it's an indication, and therefore, in order to make the final determination, if we make all three, you have to look to the soils analysis. Is that correct?
That is correct. And only to add for the observation on the second Casey report, the more we looked at their analysis, the weaker the evidence on vegetation became to us.
Right. I'd just like to add, if I may, that you're correct in indicating that there are, and Dr. Calvo correct in indicating that there are two sets of conclusions, one being the conclusions of our report, and the second set of conclusions presented in our opening presentation based on analysis of significant additional data presented by the second KC report. And in terms, again, of your question, I believe that I would say our final conclusion does not depend upon the analysis of soils. As, again, as you've illustrated and everybody is aware of, we must have all three conditions: hydrophilic vegetation, hydric soils, and hydric condition. The absence of hydric vegetation would mean we don't need to know any soils information because we need to have all three. And my analysis of the available plant species lists and coverage data do not permit a conclusive determination that the polygons delimited represent wetlands based solely on the hydrophilic vegetation criterion.
Thank you, Chairman.
I have no questions, Dr. Langstroth, Dr. Calvo.
Thank you.
Sir, I do have a follow-on question from Mr. Baker's question.
Please.
Gentlemen, Mr. Baker used the word dispositive in his question, and this seems to me to go to the core of this analysis. You've testified today that you did identify potential evidence of hydric conditions and hydric vegetation. That was where we concluded. Based on that, and let's assume that there are only two criteria, we'll put the soils to one side because that's beyond the scope of your report. Notwithstanding the fact that you could conclude, for example, that Mexican ground grass doesn't only grow in wetlands, it grows in other environments as well. What is the orientation of the question of whether it is dispositive? Would one err on the side of identifying a wetland, or would one err on the side of not identifying a wetland? And it's a very important qualification for the purposes of protecting the wetland.
Yeah, let me start with a comment. First, I wouldn't want to err on either side. We would like to find sufficient information to make the right decision. And my claim is that sufficient information to make a final decision, even on those two parameters, has not been, even at this point, completed. After the first Casey report and my observations on the site, our report concludes that it looks like the vegetation could meet the criteria. After the second report, where more data was produced, actually that observation became weaker. Now we're less convinced that even the vegetation truly represents a preponderance of hydrophilic vegetation as defined in the Costa Rican law.
So I have two follow-up questions from that, if I may. The first is, you've used this word a number of times in your presentation, and you've just used it now. Preponderance means the majority. You do not need to find a majority of species under any of the legislation in order to determine a wetland. Is that right?
Under the Costa Rican legislation, that is correct. There is no criterion that says preponderance of, because the criterion itself does not relate to a list of species or an abundance of different types of plants. It specifically relates to the presence of hydrophilic vegetation, which is defined by the presence of what they define in paragraph 5 as hydrophilic plants, which are plants whose life cycles are associated with aquatic conditions, particularly reproduction, and also that have structural adaptations to life under such conditions. That is what is stated, paraphrased, in paragraph 5, or I should say Article 5 of the Menai Decree. Then paragraph, or I should say Article 6, then establishes that there are three necessary conditions at a site. The first being hydrophilic vegetation. And then it sort of redefines hydrophilic vegetation again as that vegetation types associated with aquatic and semi-aquatic environments. And so I agree that there is no attempt in the Costa Rican legislation to state that there has to be 51% or any other number, any other sort of numerical preponderance or dominance of species. Rather, it specifically depends on a type of vegetation. And again, vegetation is something that is comprised of a number of individual plants living together in a certain habitat. And these plants may be from one or many, many species living together. And in order to be hydrophilic vegetation, there should be some evidence that hydrophilic plants, we won't say dominate or have a preponderance, or when we have a condition where we have both upland species in a polygon, when we have polygons delineated that include dry forest trees, mature dry forest trees, it is very difficult for anybody to come to a conclusion that that polygon, as delineated, can be called a wetland without much more additional information. And so
So to clarify, sir, because I'm afraid this doesn't settle it for me. You've said some evidence, and then you've qualified yourself with dominate or preponderance, but you've already admitted that the law and no requirement exists that there be a preponderance. So can we just clarify step by step? Preponderance is a term that you import into this analysis, is that right?
Preponderance is a term I import into the analysis based on the application of a modification, a hybridization of a North American USDA approach to identifying species as either wetland, upland, or some intermediate category. And so by implication, I believe that the attempt of the KC2 report to present botanical data, present percent coverage, by implication, shows us that there's something important about percent coverage, and there's something important about the number of species. Now, we know that the KC report does not conclusively state that there is a preponderance or a dominance of wetland species because none were found. There was no such preponderance found. And again, I refer you back to paragraphs 18 through 25 of the KC report, where we are misled by a series of statements that say that these sites have wetland species and wetland vegetation of X percent cover. But when we look at the data, we're finding that the W and the W/U species are being grouped together. And I cannot find that to be conclusive evidence, and especially in a legal proceeding. I do not believe that that is an adequate level of evidence.
And if I may add back to the definition of hydrophilic vegetation in the Costa Rican legislation is very specific. They specifically talk about plants that are dependent on the aquatic environment, especially for their reproduction. So the definition itself is very restrictive. And what we have found is that the list of species, and many, I couldn't tell you how many, we could do their analysis, of the W/U species, including species like Cecropia purtata, I assure you, those species, many of those, had no adaptation for aquatic life, had no affinity for aquatic life, and are not hydrophilic vegetation. And that's why, after we read the second KC report, our confidence on the vegetation side of the equation was shot.
And if I may, because this is very interesting, sir. So I want to go back to one of the other questions, because we'll leave, Mr. Irwin is here, and so I will leave him to also respond on some of these issues. You said, Dr. Calvo, in response to the original question, that you would not want to err, and I appreciate that for these circumstances. Do you think, which way should an official who is charged with the protection of the environment under the precautionary principle, which way should they err? Should they err in finding of ignoring potential wetlands, or should they err in favor of finding a potential wetland?
They should try not to err. I'm sorry, I responded real quick.
No, I'm giving you the fact set. I don't want you to change my parameters. In a situation where you have a potential wetland and you have an obligation to protect the wetland.
I have never worked in government, so I'm not going to put myself in that position. I believe.
I'm putting you in that position.
I believe that as a government official, I would probably say, you show me that there are not wetlands, because I am believing that there are, given the preponderance of information.
And in waiting for that, if that were requested, what would you do as an official? Would you allow construction to continue on the wetland, or would you suggest it be suspended?
Again, that's a hypothetical. I have never been on government side. Unless you, tribunal, make me answer that question, I don't have an opinion.
But what is your protest? What is your protest to answering that question?
That I have never been in that position from regulator side.
Understood, and I'm not asking it from a regulator's. I'm not asking you to assume a responsibility. I'm asking you as someone who is familiar with these ecosystems.
Yeah.
Which way would you err?
If I am an administrator in a regulatory agency and there is sufficient indication that there may be wetlands there, first, as I said, I would ask that the demonstration be made that there isn't. And while that decision or that data is produced, I would probably sit on any decision.
You would what, sorry?
I would sit on the decision. I would not make a decision allowing the continuation of works that could affect, but we don't know whether it's a wetland or not.
So you would suspend the construction?
If there is construction already happening, perhaps, yeah.
Okay, thank you very much. I don't have any other questions.
Thank you, Dr. Langstroth again, and Dr. Calvo. You are released as expert witnesses.
Thank you.
Thank you.
So it's now a little bit past the time to break for lunch, but I think it is now appropriate at 1:30. And should we restart that then at 2:30? Thank you.
So just for information, I believe, but Mr. Leithley will tell me if I'm wrong, that we will be beginning with Priscilla Vargas, and then I think moving to Mr. Owen after that in terms of order. So to manage expectations, you will only see Priscilla Vargas fleetingly. We will be extremely brief.
Thank you. Okay. If court reporters, interpreters, and the parties are ready to proceed, then we will proceed with Ms. Priscilla Vargas. Ms. Vargas, are you going to testify in English or in Spanish?
Spanish.
En español. Muy bien. Muchas gracias. Posiblemente ha estado.
You have perhaps been in the room as other experts have been making their presentations. Nonetheless, I'd just like to reconfirm the procedure. After your examination to confirm your statement as an expert, you will be cross-examined by counsel for the other side, and once that has been completed, the party that offered you as witness, as expert, will make some additional questions, but they will focus entirely on the cross-examination that has been carried out by the counterpart. Any doubt that you may have concerning the question asked, you can obviously request clarification. And if you would like to make any clarification following your answer to the question, you may do so immediately following your response. Lastly, as you must have noticed, there is a simultaneous interpretation during this hearing from both English into Spanish and Spanish into English. In addition, there is a transcription. So there could be some delay between question and answer, and perhaps you should allow a few seconds to elapse after a question or an answer before continuing. This will make it much easier for the transcriptors, for the court reporters and for the interpreters. Very well, sir, I'll make my best effort. Lastly, I'd like you to please read a statement that you'll find on the table in front of you concerning your statement today. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief. Thank you very much. Thank you very much, Mr. President, and good afternoon, Ms. Vargas. Would you please start by confirming that there is a copy of your statement for this arbitration, that it is in the file, in the binder? Yes, but I do see that there are some figures attached here. They're not actually part of my report. My report goes through till paragraph 96. Thank you very much. Are there any corrections that you'd like to make right now? Yes. The first is general. When talking about the environmental fragile areas, it says in law, but it's actually in the regulations because it's an executive decree and not a law. That's my first comment. Second, footnote 17, paragraph 21. The correct citation would be the environmental organic law and not the wildlife conservation, which is the one that is mentioned in this footnote. In paragraph 41, the word implicitly is to be deleted. In 42, delete the sentence, CETENA does not require anything implicitly.
Y en el 97 debe eliminar.
And in 97, delete yet another obligation the claimant failed to meet.
Just to make those changes.
Sorry,
Señor Vargas.
And Ms. Vargas, this is before you giving us your presentation, could you explain a little bit about your professional expertise? I'm an industrial engineer and I have a master's degree in environmental engineering. My entire life, since I studied industrial engineering, I have been working in environmental matters. This has allowed me in 1984 to begin working with the prior version to CETENA, which is an interinstitutional commission that was created to study environmental impact. I was then around for the creation of CETENA and began working with the first versions of the CETENA regulation. I've seen the evolution of this to educate a country, to have environmental evaluation procedures in place to refine those regulations. The first version was not as refined as the current one. We had to regulate, we had to specify, we had to go into details. So I lived through the entire process, supporting essentially foreign investors who come to work in the country. Costa Rica has a significant economic area of foreign direct investment. Moreover, there's an agency, it's called CINDE, you've perhaps heard about it, but their goal is to attract foreign direct investment. And frequently, I receive foreign investors and explain to them all the environmental impact assessment process, and if they decide to stay in the country, support them as they obtain their permits in order to set up shop, and if necessary, support them in their daily activities once they start up in the country. Likewise with local enterprise, it could be from manufacturing enterprise, large-scale agriculture, real estate development, tourism, hotels, and even more complicated issues such as highways, airports, or fuel depots. So we have done a lot of work in environmental impact assessments. Thank you very much. Perhaps you could now give us your presentation, and with the tribunal's permission, I will let you know when you're 15 to 20 minutes into your presentation because we are under time constraints. Thank you. I'd just like to state that the presentation is in English because that's to help most of the participants, but I will be explaining and providing my statement in Spanish. The scope of my work was based on reviewing the information provided by Mr. Aven and his team, in other words, claimants, to see if it was comprehensive, if it was complete, and if it followed the environmental assessment procedures that are in place for a developer. In CETENA, we use the term developer for whoever proposes a project, and to see if they were in compliance and how it compares with what they should be doing. In order to do this, my work begins with a review of the environmental viability files presented to CETENA by claimants. Part of the research also encompasses, and COMEX provided me a comment of Exhibit 54. That was the entire design, the master plan that the claimants presented as a development. So then we come to the second section on this slide, and we found that some of the project area did not have the environmental viability, and this has been discussed, and I want to point it out because it is truly a relevant aspect for my analysis. What you see on the screen right now shows in blue and yellow. Blue, it's a condominium file, which is perhaps the one we've discussed at length, because that is precisely where part of there is some evidence of wetlands or potential wetlands, and you know all about these problems. In yellow, it's the hotel. The different tones of red, you'll find that there are 5 blocks. These are sectors for which there was no EV. That red circle shows the area where some construction work took place, contrary to other areas. And this was the beginning of construction without having an EV. And here I need to cite Article 2 of the regular procedure process of CETENA.
I have to put down an objection. This pack goes way beyond Ms. Vargas's report. The purposes of the presentation was to give a summary of the evidence in chief and to address those matters. This goes considerably beyond that, and we do not accept that that is right or proper.
Well, Mr. President, I would merely remind Mr. Byrne that we heard this morning of a supplementary from Dr. Bailey, which was responsive to reports which had already been on the record. So
those were comments based. He may have used the word supplementary, but those were just comments based on the last filing from the evidence from the other side. This is all new. This is all new.
Well, we also heard fresh testimony from Mr. Ortiz on areas of law which were not part of his report, which the tribunal admitted in relation to the maritime zone. And Dr. Bailey may well have been responding to Casey, but the procedural order had not invited him to respond to Mr. Irwin. So I would respectfully submit this is only consistent with the practice which we've been following during the course of the week, sir.
Sorry, sir, I have to object. I mean, just as we go through this is ridiculous that we are looking at stuff that is absolutely beyond the scope of this report. I mean, not just by a little bit, not just updating an opinion the way that Dr. Bailey did to reflect what is before you, just reflecting on material that is before you. This is entirely new material.
Sir,
this is procedurally improper. We are not in a position to respond to this on the hoof from this person.
And Mr. President, I would merely reflect that everything that is referenced in this presentation is sourced from the record, and every comment is sourced from her expertise, which is being scrutinised today. So if Mr. Byrne has a question, then he can absolutely cross-examine Ms. Vargas on that.
No, I'm sorry, sir. There is one choice. Either we terminate this presentation now, or Ms. Vargas goes away, prepares a supplemental report in which she's perfectly welcome to address these matters. It's not up to us to cross-check all of this material against the file to make sure that she's within or without the scope of her original evidence. We've arrived prepared to deal with her report, and it is entirely inappropriate that we are being ambushed in this way. Either she does not present this at all, and all the copies are withdrawn and taken away, and no account is taken, or Ms. Vargas is withdrawn for current purposes, the respondent considers its position, and we will consent to a supplemental or an amended report if they so choose. That it goes way beyond the line.
I'm sorry, Mr. President. This is quite frankly absurd. Now, Mr. Byrne can get quite excited about hearing a presentation he's not comfortable hearing, but let's consult the table of contents of Ms. Vargas's of her expert report, which is on the record, and everything I can explain, and Ms. Vargas can confirm. I think we should hear from her about the scope, and she can happily confirm to the tribunal whether everything that she plans to talk about in this, first of all, number one, is sourced from the record. If it is not, we will be very happy to withdraw it. Number two, if the scope is within the scope of her testimony. But for Mr. Byrne, if I may say, to preemptively anticipate that all of this is outside of her report without having heard her is a little premature.
Procedural order stated that demonstrative materials could be used provided that it was a reflection of what's already on the file. If the information that is in these slides is information that is already on the file, then we can proceed, even though the slides themselves are new and have not been previously shown. But the supposition, the requirement is that the information itself is already on the file. So if you can identify that this information is already on the file, even though the slides haven't been newly prepared for her presentation, then we proceed. Otherwise, Mr. Byrne does have a proper comment on the subject.
I can certainly confirm that, sir, and I'd be happy to leave Ms. Vargas to confirm the same, but that's absolutely my understanding that everything that is in this presentation is sourced from the record and from her report.
If you allow us a second.
Yes, sir. Mr. President, we have confirmed that everything is either a demonstrative or it is sourced in the record.
Let me just remind the parties that under Procedural Order Number 5 of November 25th, 2016, Section 36 makes reference precisely to what we have in front of us, and it provides the ability to submit demonstrative exhibits. There is one requirement that states in that section that each party shall number its demonstrative exhibits consecutively and indicate on each demonstrative exhibit the number of the document from which it is derived. At the beginning of the respective presentation at the hearing, the party submitting such exhibits shall provide them in hard copy to the other party, the tribunal members, the tribunal secretary, the court reporters, and interpreter, and subsequently send them by email to the secretary and the other parties in electronic format. So,
Sir, I would also respectfully refer you to paragraph 26.2, which stipulates that experts giving oral evidence shall first give a brief summary of their report, followed by brief direct examination. My point is not only that there is a danger that there is new material in this. Perhaps Mr. Leithley is right to say that it is all derived. It's very difficult to check immediately whether that's right or not. But it is beyond that. I can see that there are, for example, the section near the end called Supplementary Information with a slide headed ESIA versus PGA. That is not covered in Ms. Vargas's report. This is the presentation is simply a device to summarise.
I'm afraid
the
sorry,
evidence.
please allow him to
I beg pardon, yeah,
finish.
I have to clarify a few points here, sir.
Yes, but please allow Mr. Byrne to finish.
Well, essentially, I had finished. So, I mean, the concern is not only as to its status as a demonstrative, although the extent of the presentation does make it very difficult to check whether paragraph 36 has been complied with. But it is beyond that. And I only give the reference I did by way of example, that actually Ms. Vargas is going beyond her report.
Mr. Leithley?
Absolutely, Mr. President. I have absolutely no idea how this has become an exceptional case. Ms. Vargas is about to present her report. Everything that is in this demonstrative, in this presentation, is either a demonstrative, which is to say a visual representation of a point that she wishes to make, which is derived from her report, or it is an illustration such as what is behind you at the moment, which is an extract from a document where we've been very diligent in citing every single document in these examples so they can verify its content. In the one slide that Mr. Byrne has identified as supplemental information, it's because we didn't know how much time we would have. So if Ms. Vargas is able to get through all of the slides, she will. If she's cut short, then this would have still been available to the tribunal, and that particular slide is sourced in her report. She talks precisely about that issue. So I'm a little bemused, sir, why Mr. Byrne is so agitated by this point. We have sat and taken in good faith all of the presentations that have been given, for example, Dr. Bailey today, who on his cover sheet, like I say, was supplementary. We have no objection. We want the issues to be fleshed out and we want the issue to be presented. Now, if at any point Mr. Byrne identifies an issue which he believes is not sourced in her report or within the scope of the expertise that her report illustrates, then very happy to hear or to have that part struck from the record. But I think the tribunal will realise that at the end of Ms. Vargas's presentation, it will be squarely within her expertise, which is what Costa Rica is entitled to present to you. The only other alternative, sir, I would say is if Mr. Byrne wants to make an application that Ms. Vargas be asked to leave the room, he take time, which I would ask be on his time, to identify the slides that he has a particular objection to, and if there is an agreement, if there's a decision by the tribunal that that slide be removed, we will remove it. We have no issue with abiding by the rules, but I do not understand why this, having heard 3 minutes of Ms. Vargas' presentation, gives Mr. Byrne the right to conclude that she's beyond the scope of her report.
Well, the presentation of Ms. Vargas does have to be a summary of her presentation because this is the objective at this point, her presentation today must relate to the report that she has submitted. If there are materials, demonstrative exhibits that are already on the file, which are referenced in the slides as to the source, then we can proceed. If you, Mr. Byrne, or your legal team identify that there is some information which is not, then please raise it, but let's otherwise allow Ms. Vargas to continue. But you are aware, Ms. Vargas, and I will repeat this if necessary in Spanish, but you are aware that this presentation is and should be a summary of your written report that has been submitted. Okay, thank you.
Ms. Vargas, I think you just said, yes.
So, por favor.
Please go ahead. Thank you. As I was saying, the issue of areas where there was no EV file became important for the analysis because, based on the executive decree that you see on the screen, which is the regular procedures, regulations of SETENA, is the backbone for all rules to conduct environmental evaluations in the country, or assessments, and it clearly says that the environmental assessment has to be carried out prior to carrying out any project and development activities. And this is very clear in what you see in the red circle on the screen. The regulator went beyond this, and it is especially relevant in the case of segregations for urban use. A segregation for an urban use is quite clearly the miscalled easements, and it is precisely the area in the red circle on the screen. Not only can you see them on that plan on the screen, but construction began. This is an aerial photograph showing the miscalled easements. There are actually sort of roads that make it possible to have lots, and you can see that a number of them already have construction. Not all of them, but there was some already with construction on the lots. This means that there is a violation of what I mentioned a moment ago, that the EV must be obtained prior to beginning construction. And I'm saying this to emphasize the point that what has been stated or suggested in other presentations and pleadings is incorrect, that the easements could, in a certain manner, perhaps did not require an EV. They did need it because they are an urban development, as mentioned in the article that I just showed you of the regular procedural regulation. The area in pink on this screen says that the EV process depends on the size of the construction and some other aspects pertaining to the land. We have also heard about a number of SETENA resolutions. Perhaps they were not stated by name, but you see them highlighted in yellow on this screen. And I want to refer in particular to 583-2008. These are resolutions that those of us who work on EIA talk of them as the exception or exemption resolutions. Why exemptions? Because when the SETENA established its regulation, it was very, very broad, and the organic law, environmental law, imposes that the reason for having an EIA was established in such broad terms that absolutely any human activity that has an impact on environment had to go through an EIA with CETENA, which meant that CETENA was overcome with projects that were ridiculously simple, such as the repair of sidewalks, changing windows, or strengthening some walls or whatever. So in quantity there were a lot, but their complexity was exaggerated. They were quite simple. So a number of resolutions were issued, and it's the ones that I highlighted on the previous screen, which was to obtain exemptions from CETENA of activities that are deemed to have very low environmental impact. By very low, CETENA made it absolutely clear that one could not consider as having a very low environmental impact any activity being carried out in environmental fragile areas. This could include wetlands, rivers, creeks, or any other kind of fragile area as defined in the regulations. There are many points in the resolution, but the most iconic are a clear example of what we're dealing with here, and they refer to individual homes. In other words, if a family buys a lawn that has all its services that have been provided in a development that had been duly constructed, then obviously that family did not need to conduct their EIA. The neighbor likewise, and another neighbor also have their own EIA. So these cases are exempted. It's understood that the development already has its EV. The same applies to road repair work. Now, this cannot be compared to what took place in Las Olas without EV in the so-called, or the badly called, area of easements. Because we've already explained, this is an urban development with 72 lots, and furthermore has impacted areas that at least could potentially have wetlands. So the exemptions definitely do not apply to this case. This map simply shows that the permits were obtained for individual lots. They were filed with municipality. This is important to understand because Resolution 583, the one I just explained to you, it's not that you don't need an EV, but the EV is understood as being awarded with the municipal permit. So somebody could say, if I have a municipal permit, I have my EV. And that's why it was so important to explain that Resolution 583 under no manner whatsoever can be deemed applicable to an urban development of 72 lots where roads and services were put in place as this case. This is a resolution that is in the presentation. This is an extract from Resolution 583, just so you better understand what kind of activities the resolution refers to. They're all of a very low environmental impact, all of these activities. On this slide, we have a description of, well, the slide gives an example of the different EIAs in the country. First, we have the complex ones. That's for highly complex projects with high environmental impact. And I'm reading this slide from right to left. Category B are intermediately complex projects. They might need an environmental management plan, as was done in the case of the Las Olas project. Category C is 1,000 square meters, for example. And where it says municipal permit, that covers the cases covered by Resolution 583. There's not a Category D, but if we were to have a category D, it would include these. They have very low environmental impact. Just to give you an example, developments of 0 to 10 hectares, such as the easements, where we'd be talking about 3.6 hectares, these are category B, and they would need an environmental management plan. They're not a D2, which is a simpler category, and even less the municipal permit category, which would be yet another subsequent category. If we were to look at the overall Las Olas project, then it would obviously have to be category I, where it would need an EIA, because that is the most complex instrument to assess the environment. This brings me to an issue of which you've heard a lot, and this is the fractioning of the EV. No mention was made of the 72 lots. No mention was made of the other commercial lots, which were the ones I showed with the red circle on the first screen, or in the different red colors based on the 72 lots. And even if there had not been any commercial lots, or if the 72 urban lots hadn't been there, the EV should have been comprehensive with between the hotel and the condominium if they were part of a single project, and provided, and that is what is provided. In that case, it should have been a complete EIA as to the geographic space, and this is the point that we're trying to make with this slide. In addition to being geographically integral, it should also have been comprehensive when looking at the ecosystems that exist on the site. And I'd like to spend a moment on this. We're not saying that fractioning is simply to split files or to split a large project into smaller files. When we study ecosystems, the evaluation of the whole differs from the evaluation of its parts. We cannot understand the wealth of a forest if we only look at its trees, and we cannot understand the wealth, the value, the dynamics, or the potential impact on an ecosystem if we split it, if we fraction it, and if we look at it as small disconnected elements where the overall value is not assessed. That is why Article 94 of the Biodiversity Law is not a legal formality, despite the value of such formalities, but after all, I'm an engineer. But from a technical standpoint, it is inherent to a correct environmental impact assessment to conduct a comprehensive integral assessment, because otherwise you're detracting technically from the tool. And that is why this fractioning into different files not only violates Article 94, but it also violates the correct process for an environmental assessment. This also reminds us of the sensitive areas issue, which we have already mentioned and is mentioned in a number of reports. Sensitive areas that Mucio identified, to the enormous surprise, quite honestly, because when I read Mucio's report, he says that they were identified from the very moment he stepped on the site. That really induced me to shock, because I couldn't understand how a professional can say that he reached the site, identified the areas, and these areas, well, they're not even disclosed. They're not indicated to Setena. Setena wasn't informed about the existence of these areas. Environmental practice, the way I know it, is quite the contrary. One goes to the site with the geologists, biologists, and the appropriate professionals. We draw up a map of the information generated by each one. We superimpose the site design and ensure that the environmental conditions of the property are respected. And we then present that information to the Environmental Secretariat, because otherwise it's impossible to have an EIA. I can't have an EIA on a wetland, a forest, a river, or an ecosystem if I don't characterize that ecosystem and say where it is located on the property. And quite clearly what Mr. Mucio described in his report was environmental fragile. And it's not my own words, it's his own words, where he said that areas that could be considered fragile or vulnerable, and those are the areas that I will be addressing in a few moments. But let me first say that environmental fragile areas are not an ethereal technical concept, but this is a concept that is legally specified, and there are two kinds. One is already defined in the regulations as expressly list national parks, protected wildlife areas, wildlife protected areas, areas with wetlands. But the regulator furthermore has said that areas that are environmental fragile have technical limitations for environmental reasons, such as Mucio pointed out in his report when referring to those three areas that are indicated by circles. Furthermore, I was very struck by seeing that the author of that report says that environmentally fragile areas are defined as such to assist the environmental assessor to conduct the analysis, so that nothing is hidden that can then hinder the research, but so as to, from the early stages, give some guidance about what areas require special care for technical environmental issues. There is another area which was a fragile area. Proti identified it, and we have heard whether or not the Proti report was known in good time or not, but it does exist, and there is no doubt that Mucio's information and Proti's information were confirmed in the ex post analysis by the reports from Dr. Bailey and by the ERM experts that I have had the opportunity to read. Here we have four maps. Above Mucio and Proti, the lower line, the depressions where ERM found potential wetlands, and the valleys, the bajos, where Dr. Bailey found hydric soils that could be indicative of wetlands. This is a superimposition of all the previous data, and if we zoom in, I'd like to show you Mucio's Zone 1, which you may recall is on the top part of the screen. You see it on the major screen, and now zoom in. And all the criteria can be found here. Mucio knew early on and said so that there were fragile conditions here. Mr. Irwin has the W5, that is the wetland identified by Mr. Irwin. D3 is the depression that could potentially be a wetland because of its vegetation that was identified by ERM. B6 is Bajo 6, as Dr. Bailey described. And I don't know if you can read it clearly on the screen, but if we zoom in sufficiently, and I'm going to try and hold my hand steady there so that you can see it on the screen. But what we're looking at here is the project's development treatment plant. You have the main access to the development here, and this is a waste area. I cannot conceive that an EIA was conducted for this. There was a submission made to CETENA, that is true, but CETENA was never informed that this was an environmental fragile area where all experts agreed that there are characteristics of environmental fragility. That is not an acceptable environmental assessment in any country under any concept. This exercise can be repeated in other areas. Let me just give you two examples because my time is almost up. This is a close-up of the area where Proti identified the famous swampy zone. Mucio, his sensitive area 2, Dr. Bailey, Bajo 2, ERM, Depression 1, and Kevin Irwin, Wetland 2. As you can see here, an important proportion of this wetland was going to be turned into lots for the easements here, or roads, and that wasn't the right idea either. Another part was a rain easement, that in this kind of development is a drainage mechanism, and yet another part was going to be a park, as Mucio pointed out. I'd like to draw your attention to the fact that a wetland is not a park. Park, based on urban development rules in Costa Rica, must be equipped with children's games and swings and things so that people can go to enjoy the day and to walk around. But a children's park cannot be a wetland. This isn't even compatible, even if it's a green area, and it's not in accordance with the design for this site as provided by the project. And we could do the same with each of the wetlands that have been identified, but I think this provides a good example to show that an EIA was not conducted for the ecosystems on the site, nor was there a correct recognition of the ecosystem's characteristics. And to identify those characteristics for those ecosystems was obviously the developer's responsibility, and even more so if there were identified fragile environmental areas. In summary, and I'll be concluding here, there is absolutely no doubt for me that the request for an EIA as submitted was deficient because it didn't comprise the full scope of the project. Furthermore, it was deficient because it did not declare sensitive areas that were known, or perhaps not known, but they were not declared. Part of the project had not received an environmental assessment, and the site design obviously does not comply with the environmental characteristics of fragility as recognized on the site. The country has different environmental instruments: the municipal permit that I showed you, the D2, the environmental management plan for projects of type A, and they are precisely in place to guide and indicate how deep are the requests for this kind of project. In submitting this kind of a project with its appropriate complexity, a certain environmental path was followed that made certain requisites that are not demanded for in the most serious level would have been required, and that way the site design would have had to be better adjusted to the specificities of the land. Very well, thank you very much.
Just to say as a note, we maintain that the presentation has indeed gone significantly beyond the scope of the report. We propose, rather than waste time now dealing with that, we will explain that in correspondence to the tribunal, and we can deal with it after the hearing. Ms. Vargas, your report was appended to Mr. Irwin's second report, that's correct?
Sí, señor.
Yes, sir.
There's no statement here, is there, of the scope of your instructions, is there?
Sí, señor.
Yes, sir.
Did you receive your instructions from Mr. Irwin, from counsel for the respondent, from COMEX? From whom did you receive your instructions in relation to this matter?
Del señor Erwin.
Or Mr. Irwin.
You haven't recorded those instructions in order that we or the tribunal can assess your opinions against those instructions, have you?
Están en la presentación.
They are in the presentation. In the written report, no.
Not. You have set
I'm
out...
sorry, could you start the question again?
Sorry, they're not set out in the presentation, they're not set out in your report. We do not know the basis on which you've expressed your opinion, do we?
Eso es una pregunta.
Is that a question?
Indeed it is.
Bueno, me acaba.
Well, you've just heard me say what it is.
Can you point to a slide or to a page in your report where you set out your instructions?
Creo que la pregunta
I think that the question is, the more direct question is, from whom did you receive the instructions, and are those instructions reflected in your report?
Las instrucciones
The instructions, I received them from Mr. Irwin, and the summary of the scope is slide 1, I think, after the cover of the presentation. And of course, it's very summarized because it is a presentation here.
So this slide that I'm showing you is these set out your instructions. Is that right? Is that your evidence?
presento eso como
I submit this as a summary of the scope that was requested from me.
Well, for the tribunal's benefit, we do not accept that those are adequate or even remotely adequate instructions in order to understand the scope of Ms. Vargas's testimony. Ms. Vargas, could you go to paragraph 52 of your report? I'll read the text. It's just 2 sentences. You say, as part of their D1 submission, the claimant submitted a geotechnical engineering report prepared by Techno-Control SA, the Techno-Control report, and you then footnote 45. You continue on page 14 of the same report. There is evidence of bodies of water which are protected under Costa Rican law. Now, looking down at footnote 45, you will agree with me, won't you, that it refers to R13 and then has the text, complete D1 form for condominium site, November the 8th, 2007. You agree with that?
Sí, señor.
Yes, sir.
In the file in front of you, can you go behind tab 2? You will see a copy of exhibit R13. Within that exhibit, I'd like you to go to the Techno-Control report to which you refer. Now, if you look in the top right-hand corner, you'll see it's not very clear, but there are stamped page numbers. I'd like you to find, it's probably about 20 pages in, the page numbered 000187. So if you see at the top right-hand corner of each page, look at the pages. There are some not very clear numbers. If you could just find page 000187.
And mine at least is numbered back to front,
Right,
so
right.
187 is the beginning of the report.
You have it?
Sí, señor.
Yes, sir.
Very simple question. Could you just read the addressee, the addressee of this report, starting with the word señor near the top?
Mauricio Mucio.
Mauricio Mucio.
Thank you. And below that?
Proyecto M.
Project in Playa Chamán in Punta Ballena.
So this document is not about the Las Olas project, is it?
A mí me parece que sí.
I think it does refer to it, even though the geographic reference is wrong.
Apologies. I put it to you, this is not a document that relates to the Las Olas project. You didn't contact Setena to discuss the environmental viability permits that they issued in respect to the project, did you?
Correcto.
Correct.
So you are not aware, are you, that in 2004 Setena issued an EV covering the entire project, include the condominium and the easement section? You're not aware of that, are you?
Esa no es
That's not the whole project. The whole project, even if that were the case, includes commercial lots that are not described in the scope you mentioned.
Apologies for interrupting, but you're wasting time by not answering the question. You are not aware, are you, that in 2004 Setena issued an EV covering the condominium and easement section, are you? Yes or no?
sí.
Yes.
Thank you. And Setena, nobody from Setena is before us in these proceedings, are they?
Correcto.
Correct.
I have no further questions, sir.
Okay, thank you.
Nothing from us, sir.
Dr. Nicken? Okay.
I have one very brief question, if you can help me with this. At what point does the Setena judge what is a complete project? I give you the following hypothetical example. A piece of land is owned. It's a large piece of land. The person who owns it does not have the money to develop the entire thing, so they want to develop a portion of the piece of land. Now, in the future, 15 years from now, they hope they'll have a huge master plan development. But they don't have the resources to do that now. What do they have to submit to Setena under what you've been telling us for approval of an EV? Is it what they can afford to do now, or what they hope to do but may never be able to afford in the future? Help me understand that line.
Depende.
Well, it depends. It depends on the position of the developer at that point. If the developer has the ability, let's speak specifically of Las Olas. If Mr. Aven had access only to the easements first, which he states was his first stage, at some point I heard that in his statement, I think, and if he had submitted an EV for that first stage, and years later he can buy the property for the condominium, which I understand was the second stage, well then the procedure is that you do a D1 for the first stage and then another D1 for the second stage, and afterwards you bring together both files. That is a possible mechanism, and the same goes for the third and fourth stages as they come up, if they come up. Now, a different case is when I look at the case, I don't remember if it was ETSA or who was a consultant who prepared a site master plan for Mr. Aven from day one or from day zero, where the whole development that he wanted to create was already conceptualized. So in that case, the obligation is to do the whole assessment of the whole master plan that he plans to build. Now, you have both possibilities. In the first case, you have the first, second, and third, and fourth EVs that will be carried out in a cumulative fashion, integrated each time in independent files, because that is what Setena demands, because then they can come together afterwards. And then in the second case, a comprehensive report is submitted for everything from the beginning.
Exactly, and that's the line I'm trying to help me understand. Because the only thing that I heard that was different from the two examples that you used was that in the master plan community, he owned all four parcels from the beginning. But that doesn't answer my hypothetical about the resources being available to do that. So in other words, I may conceive that I'm going to build a new capital city for the United States, for those of us that are unhappy with the current election. But it may take me a while to do that. So at what point would I have to talk to Setena? Would I have to talk to them when I conceive the master plan? or when I had the resources to build the master plan?
Cuando
When you conceive it. As a matter of fact, we have projects that develop in a 20-year period or even longer, and EV is done off the master plan, and then you do it in stages. The developer himself doesn't have to be the owner of the lots to be able to do the environmental assessment. Sorry, not the EV, but the environmental assessment. And from that point of view, there is flexibility, and no type of warranty or collateral has to be given from the beginning necessarily. Everything can be submitted in stages. The only important thing is that the environmental assessment be done comprehensively.
So, just to press you on this point a bit further, let's assume that I decided I had wanted to retire to Costa Rica, and I decided that I would cash in one of my pension funds, and I had bought all of this property for myself. And I decided I was going to put only one house on it. And I do that. So I go through and I do whatever I need to do under the D2 analysis, because I now own all this property, and I build myself a beautiful house and a resort on all these hectares. I die in a surfing accident, and 5 minutes later, my children decide that this is a perfect spot for a master plan community. So is everything that I have done out the window? Is it when they conceive that they want to do this? Is it when they contract with an architect to design a master plan community? Is it when you have the investor pool? In other words, I'm trying to help draw the line, because it's very easy with the standpoint of hindsight to say, gosh, if you're going to do everything at once and you have all the resources to do that, that maybe you should do it this way. But this decision is often made prospectively, not retrospectively. So how does Setena answer that? And what regulations would you point me to answer that?
The answer is not necessarily specific. What Setena requires is that before building, period, in other words, before building each stage, before building all of it, if you have the funds for all of it, or before each stage, if you have funds only for each stage. But once again, you don't need to have the funds to develop a stage in order to be able to assess it. To assess it is much cheaper than to develop it. So in this case, there were studies that covered the whole property. It just simply wasn't stated that there was going to be a prior stage in the easement area.
So what I take from that is that there really is not a hard rule. It's more a judgment call about what you ultimately intend to do about the property. And you're saying Setena wants to know what you're ultimately going to do. And then you will decide whether it's a D1 or a more restrictive. Is that correct?
To the best of your knowledge in that moment. Esa oración.
That sentence in English clearly explains the meaning in Spanish. If you didn't know that there were going to be later phases, then there's nothing wrong in not assessing them at the outset. But if it was known, then quite obviously there is non-compliance with the rule when the later stages are not declared.
Thank you, Chairman.
No entiendo.
I don't understand how this contingent system, whether one knew or didn't know, whether it is better or worse protection for the environment. If there's no difference, then why do you set it out as a difference? Well, thank you for that question. Let me be clear. On the assumption you didn't know, the evaluation assessment is for the initial phase of which you know is going to happen. And when an additional phase is added to your project, the obligation is to see the cumulative impact of the development in order to be able to always imbue it with this sense of integrality. That's why I said it is possible to unify or to link files afterwards. Otherwise, the environmental aspect of the project, the old part and the new part, will not be viewed as a whole. So it is correct to declare, but then the second phase could then be presented showing that it is linked to the first one, and that way you establish all the interrelationship and links between the two. Thank you. I have a question. The Claimants Council asked you to look at the report that appears from page 000187, and I'm referring here to tab 2. This is an annex of Exhibit R13. And this is the reference showing that this report is addressed to architect Mauricio Mucio, but it refers to a different project, not the Las Olas one. Have you got it before you? Could you tell me what the relevance of this is? Help me understand why architect Mucio attached to his D1 request to Setena for the Las Olas condominium project, why did he attach the report from another project? Well, quite honestly, my impression is that this report does actually correspond to Las Olas, and the geotechnical study, because this is a geotechnical one, talks about the soils and the sedimentation of the construction. It's one of the 7 or 8 basic studies that is required by regulation, and they are to be attached to D1, as well as a biology, geology, hydrogeology, archaeology, all of those reports. It's a long list of studies that are to be annexed. And the soils geotechnical technica is one of them. But how did you come to that conclusion that this one actually does correspond to the project? What is it that induces you to believe that it is in fact this project that it refers to? I'm looking at some pages further into the document. For instance, page 174, 000174. And even the plan for the site looks different. Well, more or less. It's a terrible map. I won't argue that. It's quite shameful. It's a very poor, very bad map. But if you look at the upper portion, you can see a wide street that seems to say Carretera Costanera, which is the name of the main road between Jaco and Quepos, and it is the road that is adjacent to the northern part of the Las Olas sector. And in the southwest, there is another smaller road with some limited access, and it looks very similar to what we have seen in the context of Las Olas. I get the impression that it is this project. However, none of the conclusions that I pointed out changes in any way based on this report. But it's simply that. It's your impression that it refers to this project. There's nothing in this document. Well, I cannot prove that it was conducted on the site. There is no clarification by the Las Olas developers that this is a mistake either. So I assume if they didn't correct it, then this is the right document in the file, and I find that it is consistent with what we see on the site, although we're not going to query the poor quality of the map.
perhaps I should ask first Mr. Leatley, because this is his exhibit, R13. Do you have an answer to this question? Why do we know, or why we have reason to doubt that this might be the Las Olas project?
Sir, I'm afraid you're testing my technological know-how. I know it's unsatisfactory now, but can I take instructions and we can respond in due course or in post-hearing briefs?
Okay. Mr. Byrne, this would have been part of Claimant's filing made by his advisor or Claimant's advisors.
Yes, it's our understanding that this document does not relate to Las Olas. It relates to another project on which Madrigal Museo were working. We don't know why it's been produced in this arbitration. All we can say is it has no relationship with this project. Hence the questions that were put. We're perfectly happy for this to be addressed after this hearing. It may be something where it's necessary to go back to Mr. Museo, frankly.
Okay. Thank you very much. Any follow-up questions in respect to the questions? No? Bueno, muchas gracias, señora Vargas.
Thank you very much, Ms. Vargas, and good afternoon.
Would you like a 5-minute break to prepare the next expert witness? Okay.
We could have 10, so I could make it very brief.
Okay, that'll be a 10-minute break.